Welcome to Guardians of Innovation, Patent and Trademark Law.
Hello and welcome to Guardians of Innovation, Patent and Trademark Law with registered patent attorney Vincent LoTempio. I am your host, Kevin Rosenquist, and in today's episode, we're diving into an essential topic for anyone navigating the world of trademarks, the 5 levels of distinctiveness. Vincent, so good to see you. Welcome back.
Hey, great to see you again. It's always nice doing these. This is a lot of fun.
Yeah, absolutely. And it's interesting stuff too. I've had to trademark things before and all that. It's definitely there's some waters to navigate, but it's nice to have someone like you here so we can get down to the nitty-gritty of it. So why don't we start at the beginning and what are those 5 levels of distinctiveness for trademarks and how do they rank in terms of protection?
Yeah, so when you first pick your trademark, you have to use this spectrum of distinctiveness to determine the strength of your trademark before it's ever used and before anybody sees it. So these are inherent distinctiveness versus acquired distinctiveness. So, for example, McDonald's is just a descriptor of somebody's name, right? It's the second level of inherent description. But it acquires distinctiveness over time because they sell millions of hamburgers. So let's talk about those 5 levels. There's generic, descriptive, suggestive, arbitrary, and fanciful marks. So generic is like soap, right? You can never register a trademark like soap because anybody that's selling soap gets to use it. Descriptive is like we talked about before with the McDonald's is it can become your trademark, but at first it's just describing what your goods or your product is. So I like to tell people to start with suggestive marks, like Dunkin' Donuts. Like, what are you dunking? You're dunking your donuts into coffee, and they're selling coffee. So they're suggesting that you purchase their coffee. And then arbitrary, Apple computers. Apples have nothing to do with computers. So, that's just an arbitrary name that they throw on it. And it becomes very distinctive, very strong out of the box. And then finally, fanciful marks are just words that you make up, Xerox or Exxon or Google. So those are just made up names and they're arbitrary and fanciful, and they're very strong marks when you first get your trademark.
Yeah, I feel like that definitely in the tech sector that has become a thing, or that not has become, it's been a thing for a long time, using those sort of words that don't really mean anything, but they become, Google is now it's a verb.
Yeah, exactly. And I think with Google could be argued that it's almost generic now because people say just
Sure.
Google it. And what
Yeah,
they mean is go search it. But
right.
there is actually a lawsuit, and Google, doesn't want it to be considered generic. Like think of some generic names like aspirin and escalator, Kleenex. If I say to you, go to the store and get me a box of Kleenex, you might come home with some Scott tissues. But if I
Right.
said to
Yeah.
you, go get me some tissues made by Kleenex, it's more likely you'll come back with the right brand.
How can a business make a descriptive trademark registrable? What do they need to do?
So we talked about before about the difference between inherent distinctiveness and acquired distinctiveness. So if you have a descriptive mark, there's a good chance you're going to end up on the supplemental register. And basically what that means, it's not going to have all the benefits that the primary or principal register would have. So it has to become a trademark. So and how does it become a distinctive trademark? Through advertisement, people start to recognize it. You use it over a period of time. So those are things that it can become registerable, but it starts off very weak and it's just descriptive. And if somebody was to copy your mark, their argument probably would be that it's just describing what we're doing and they can't stop us from doing it.
And how do trademark examiners evaluate the distinctiveness of a mark when reviewing a trademark application? What are they looking at?
So the trademark office is never going to look at acquired distinctiveness. You could argue acquired distinctiveness, but they're going to look at inherent distinctiveness right off the bat. And
Okay.
they're basically going to say, look, this mark is not inherently distinctive. It's just descriptive, or it's even generic, and they're going to reject it. So you're going to start off very weak. And even if they don't reject it, like I said, you might end up on the supplemental register, which means you're stuck there for 5 years and you can still use the circle R, and you can still say you're a registered trademark, but there's no presumption of ownership. So when you have a registered trademark on the principal register, there's a presumption that you own it. It's always a rebuttable presumption, and somebody can say, hey, I used it first before they ever used it, even though they registered it before me, and they'd have to prove that they used it first. But it starts off with a presumption that they own it because they registered it on the principal register.
Okay. What tips do you have for businesses to make sure to help them in their case of getting that distinctiveness?
Yeah, so I think you have to look at the spectrum. You have to try to come up with something that's more ingenious, like Dunkin' Donuts or
Hmm.
copper tone. You know, you put this liquid on your skin and you're going to get this copper tone look if you lay out in the sun. So everybody wants Joe's Camera Shop because people are typing in camera shop, but camera shop really isn't protected, right? Because it's just a generic name. So I think you have to come up with something creative, suggestive, and you know, the hard part of picking an arbitrary, like just throwing an orange and say orange computers or Apple computers on it, is that nobody's typing for Apple computers right out of the box. Although right now probably a lot of people type Apple computers because it's so strong, and you know, it's acquired distinctiveness over time and everybody
Right.
knows what Apple computers are. So that's the hard part. But the thing is, if you are right, Steve Jobs, and you created Apple computers and you call it Apple computers right from the beginning, well, now it's so strong, and it's probably that trademark is worth more than, you know, the brick and mortar itself.
Can you explain the concept of secondary meaning and how it applies to marks that are maybe not inherently distinctive, like descriptive marks?
Yeah, so the secondary meaning is like acquired distinctiveness. Over time you acquire distinctiveness. Like Best Buy, they started off on the supplemental, and they because they're saying, "Oh, we have the Best Buy." Everybody says we have the Best Buy, but now if I say Best Buy, you picture that yellow sign out in front, you know, and it's acquired distinctiveness. They were on. You know, the blimp going across, you know, at the race car tracks, and in the, you know, the millions of stores all around the, I don't know if there's millions, but you know, I'm sure there's a Best Buy in every city across the country. So it becomes acquired distinctiveness. So if you have to prove secondary meaning or acquired distinctiveness, you'll have to show, you know, thousands of dollars versus advertisement. How many people come to your website? How many sales have you made? These are all things that will prove that you've acquired distinctiveness over time. Obviously, if you're a new entrepreneur and you're just starting out with a brand new mark, there's no way you can prove that. Even if you have, you know, $100,000 worth of sales, there's
Mhm.
no way you can prove that, you know, it's recognized throughout the consumers and people recognize this mark. And that's what brings it value, even though it might be a descriptive or a lower end of descriptive or suggestive, and it's not a strong mark. That's why I always say pick a strong mark from the start. And the other thing is too, a lot of people try to pick the same mark. I mean, you can't imagine. It's so hard to, it's like domain names right now. You try to pick a new one, it seems like they're all taken. You know,
Yeah,
and every time
yeah.
you think you've come up with this creative name, you type it in and it pops up, it's there. So the more you lean towards that other end of the scale, the more the chances that you're going to be able to get it through. I just had somebody call and they basically spelled a word with a bunch of different X's and Y's in it. And I'm like, well, this is going to be good because it's almost like you created this new word. And there is a problem with phonetic equivalence. So if somebody's using Z's and you're using S's, or you're going crystal clear cleaners with K's, and somebody else does it with C's, the trademark office will look at that as an equivalent. It's the same thing. But if you have, you know, if you make up a word like Google or Zillow, you know, it doesn't have any meaning on its own. It's very strong coming out of the box.
For people like maybe that are too far on the lower end, the distinctiveness of a mark, maybe even if they see it as distinctive, it definitely impacts the chances of being successfully registered. And maybe if it lacks that distinctiveness from out of the box, as you said, then it could be a little harder to get that registered.
Exactly. And there's a chance that it won't even get registered at all because they'll consider it generic.
Okay. And then I think we touched on this a little bit, but trademarks can shift between levels of distinctiveness over time.
Yeah, yeah. So that's what I mean. It acquires distinctiveness over time, but fanciful one or that arbitrary one, it's going to be distinctive right out of the box. So it's not going to be any more distinctive because really you're just separating it. You just think of branding a cow, right? You want to make sure that your cow is differentiated out there and somebody's not getting it when they all get mixed up in the field. And that's pretty much where it started from. So you have to have a distinctive mark so people aren't confused as to whose cow is which. If you have the X with a line underneath it and somebody has it on the side, maybe that's too close to the other one and you're going to get confused. So that's the whole idea. Is distinctiveness means that when that consumer sees it, there's not a likelihood of confusion. They're not going to be confused. They're going to understand the difference between Puma and Adidas or Nike. When you look at the Puma stripe, it's kind of like an upside down Nike stripe. It's just a little different, but it's different enough that it distinguishes the two, and the consumer's protected, and the manufacturer's protected. Nobody else can put my mark on their goods. So the consumer, maybe the consumer doesn't like Puma and wants to stay away from Puma. They had a bad pair of sneakers. So now the consumer's protected because they know which ones they like and which ones they don't like.
You mentioned something that was very true. Like you can type something into Google and you're probably going to find it. It's hard to find a domain name, all that kind of stuff. So how can people, just aside from just Googling, what is the best way for someone to really conduct a comprehensive trademark search?
We bill to do a search. It's part of our services. And one of the things that I do is I bill as a flat fee. Includes the search, it includes the filing, and includes all the legal work. I always say it's not just filing a trademark application, it's all the legal advice that goes along with it. And so when we first start off, I'll take what's called a knockout search, right? And I'll just type it in the USPTO website and see if it's there. Again, you're searching for a needle in a haystack, right? You find the needle, you stop. The problem is we're searching for a negative. We hope we don't find it, right? We hope it's not there. So you can keep searching forever. So there's got to be a point where you realize you've exhausted anything that's close. So like I said, part of our service is to do that search. And what I'll do, and what you can do on your own out there in TV land, you can just go into the USPTO.gov and just type it in to see if it's there. But you still have to look for phonetic equivalents. Another thing that we'll do is to see if somebody else had it and it's dead. So if it's dead and it's been abandoned for whatever reason, it should be open. But maybe it got rejected or abandoned because somebody sued them. So we'll do a deeper dive into see why was it abandoned? What happened to it? So those are just part of the things that we do when you hire us to do a search.
I think we've talked about this in previous episodes, but we've talked about brand identity, like choosing a name that aligns with your brand's personality, values, target audience. How do you kind of coach people when they're trying to figure that part out?
The problem is that we don't want to be real descriptive of what you're doing, and we want you to come up with something that's real creative. But still, again, like you said, brand identity. If you have a law office versus you're selling balloons, you're going to probably want it to align with the level of seriousness or your comedy, I guess, and make that determination.
Yeah,
And really,
crazy
I'm
clown
not a
balloons is one
person
thing.
that
Crazy
does
clown
the
attorneys is another.
just the imaginative part of it and the creative part of it. And I've said this before on prior podcasts. We talked about, I can go home and tell my wife to put blue curtains up, but she's never going to do it. I can tell you whether those curtains are legal, whether they're against the fire code. I can tell you whether your trademark is distinctive, whether it's going to be too descriptive, but it's going to be your job to pick out that trademark.
Yeah, that's funny. You mentioned yeah, you have to think about the seriousness of your business. Like you brought up the balloons in the law office. You're not going to have, you might have crazy clown balloons, but you're not going to have the crazy clown law offices of Vincent LoTempio.
Yeah, exactly. I remember when I first started doing this that it was 25 years ago, and not a lot of people, even a lot of law firms didn't even have websites back then. And
Mhm.
and I remember I was doing a blog post, and the biggest advice I got was, look, you put in positive, good content, your SEO will build on its own. If you just type in the word patent 75 times on a web page, that might draw people there, but when they get there, they're just going to leave. I mean, I can sit on the corner of Main Street with a billboard and a big purple feather out of my hat and said, come to my law firm. Everybody will know who I am, but who's going to hire you? So, if I was selling balloons for clowns, maybe they would. But again, like you said, you have to consider when you choose your name based on what you're doing.
What point should people start this process? Like how early in their journey of their company?
Yeah, I mean, the name, picking name is the first thing, right? And the thing is, most people already have the name in when they come to me and they're already starting to use it. And for me to tell them to change it, it's like pulling the bandage out.
Yeah.
But the problem is if you start selling a product and you got 75,000 cases and you mortgage your house to put apple juice in all the grocery stores on the East Coast, and somebody on the West Coast sends you a cease and desist letter and take all those labels off, it would have been easier to never put those labels on and pick a name that was strong from the beginning than trying to fix it afterwards. And that's what I always say. My job is to prevent you from getting in the problem in the first place. And although you might not like the idea of me saying you have to change your name right from the start, it might be the best decision you ever made. And yeah, I mean, that story I just told you about the apple juice is a true story.
Yeah. So what ended up happening with the apple juice one? That's crazy.
Well, yeah, that was a big dollar settlement, and it wasn't easy. And I can't get into the facts of what had happened, but yeah, it just, you don't want to be in that situation. And I always tell people, when you were a little boy or a little girl, what did your mother tell you? Don't make a federal case out of this. My job is to keep you out of the federal courts. You don't want a big lawsuit. You don't want, and this is how you do it. And I always, I talk about a sword and a shield. That registration of the trademark is a shield that stops anybody else from doing it. You cut them off below the knees, and it's a shield. Nobody can stop you from using your own name. That's the most important thing, is to get that settled before you do anything, before you put that sign up on the wall, and you don't have to take it down. And I have cases every day where, look, they're being sued to get their signs off the wall, to change their advertising, to go into the federal government and change their tax IDs and all their DBAs. It's just a nightmare. And for $1,000 that I charge for to register it and to do the search, it's some peace of mind that you're not going to have to go through that.
Yeah, absolutely. Well, great tips as always, Vincent. And thank you for joining us on Guardians of Innovation, Patent and Trademark Law with registered patent attorney Vincent LoTempio. To connect with Vincent, head to lotempiolaw.com. And as always, please like and subscribe to our channel. Vincent, so good to see you as always. Thank you so much for your time.
Hey, thank you for your help. I really appreciate you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.